You guys are just stopping me, particularly from going in and using it.
Yes.
You guys are denying me service because of my assistive devices.
That is correct.
Part 6 of a multi-part series featuring Guilford County, North Carolina. This video includes the entire audio from the second day of the District Court bench trial, which took place on August 24th, 2021. Just a quick reminder, North Carolina General Statute 7A-276.1 states as follows: court orders prohibiting publication or broadcast of reports of open court proceedings or reports of public records banned. No court shall make or issue any rule or order banning, prohibiting, or restricting the publication or broadcast of any report concerning any of the following: any evidence, testimony, argument, ruling, verdict, decision, judgment, or other matter occurring in open court in any hearing, trial, or other proceeding, civil or criminal, and no court shall issue any rule or order sealing, prohibiting, restricting the publication or broadcast of the contents of any public record as defined by any statute of this state, which is required to be open to public inspection under any valid statute, regulation, or rule of common law. If any rule or order is made or issued by any court in violation of the provisions of this statute, it shall be null and void and of no effect, and no person shall be punished for contempt for the violation of any such void rule or order.
Oh yes, oh yes, oh yes, this honorable court has now resumed the city for the dispatch of this business. God save state, this honorable court. Let me see.
Okay, thank you, Mr. Sheriff.
You're welcome.
Good afternoon, Judge.
Good afternoon, Mr. Hall. How are you?
Okay. 5 minutes late. I apologize for that.
You're fine. We just opened up court.
Actually had when I got on 85, I had a sheriff's deputy behind me until I got to High Point, so I had to go right at the speed limit, so it messed up my calculation.
I'm sure you always do that, don't you? As far as driving that speed limit. All right.
Have a seat.
All right, so for the record, today is Tuesday, August 24th, 2021. We are here in 20 CR 67643, State of North Carolina versus Michael Paul Nelson. This is a case in progress from yesterday. All right, that being said, is there anything we need to address before we resume the hearing?
Nothing from the state, Your Honor.
Mr. Holt?
I'm going to turn my phone off.
Yes, same situation applies as I indicated from yesterday as far as Mr. Nelson. I know you were copied on receipt of a new permit for covered devices. So you have that. Clearly, obviously, there aren't any issues.
He confirmed with me that he received it.
Okay, thank you. So again, so that no one is singled out, I want everyone who has any type of recording device to ensure that it is turned off and only allowed to be turned on with the permission of the court, so as not to impede the integrity of the legal proceedings by any other recorded means other than what we are currently employing, which would be the clerk of court using the audio recorder supplied by the Administrative Office of the Courts. All right. Yesterday we left it with Deputy Boyce being on direct examination by the Assistant District Attorney. So, Deputy Boyce, if you would return to the stand, please, sir, and I will have you sworn when you arrive.
He swears the evidence that you give to the court in the case now being heard shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. All right, Ms. DA, you can proceed whenever you're ready, sir.
Thank you, Your Honor. And Deputy Boyce, I just got a couple more questions for you. Which electronic device did you suspect was recording in the health department?
Both of them, because at the time, his phone, like I said, was still live streaming. He was still receiving comments because the phone was continuously buzzing with the comments, and his GoPro, as I turned it off so he could head to the magistrate's office, was also recording at the time.
And after you inventoried his property, after he's placed under arrest, did you do anything to look at either one of those devices and see that they were or were not recording?
The GoPro, the battery was taken out, but his cell phone had like a curtain screen on it. It was on, you could hear it, but you couldn't see the screen at all. You could just hear that the comments or whatever was still coming in. It was still buzzing, still chiming. People were still giving updates because they're saying they couldn't see him, they couldn't hear him. Where did we take him? They started calling the magistrate's office directly, so we knew it was still going.
And when did you notice that activity going on?
By the time we hit the magistrate's office and we started to discuss the incident that happened with the magistrate, his phone started ringing. There was people calling from Texas, New York. I think they had an overseas call at one point in time, and then he transferred to the other magistrate, and the phone just kept ringing and ringing and ringing. And they were basically saying, you know, we hear
I
people.
checked what they were saying, or this line of questioning, Judge. I don't see how it's relevant.
Sustained as far as what anyone else was saying.
And is there a nurse or medical staff at the magistrate's office?
He was taken to the detention center, was checked out by the nurse initially before his bond was secured, and she said everything was fine.
So are you aware if he received any medical treatment that night?
Yes, because that's the first thing they did when they took him over there, went to see the nurse to make sure everything was fine. Like I said, he wasn't saying anything, he wasn't responding to any questioning, he was just laid there in the chair and was not moving at all.
And why did you charge Mr. Nelson with second-degree trespass?
Because he refused to leave after being told numerous times from 2 county employees to leave the building.
Did you also tell him to leave the building?
Yes, I did.
And why did you charge him with resist, delay, and obstruct?
Because when he decided to passively resist me by not giving me his hand, then laying there going dead weight, making it harder, delaying us from taking him over to the magistrate, and his continuous outbursts that he was having while we were trying to arrest him.
Those are my questions, Your Honor.
All right, thank you. Mr. Holt, did you have any cross-examination?
Yes, Judge, thank you. Officer Boyce, you said that at the time you were working on February 4th, 2020, you were working at North State Company Police, isn't that right?
Yes, sir.
All right, and they are headquartered in Winston-Salem, is that correct?
Yes, sir.
And did you list Winston-Salem, Forsyth County as your address, your company address on the warrant?
That is a company address.
Okay, and you informed the magistrate of that address?
They know that's the address for the company, that's where they're located out of.
Okay. And how long had you worked at North State Company Police? How long had you been there on February 4th, 2020?
Approximately going on 3 years.
Okay. And had you been a police officer before that?
Yes.
Okay. Where were you a police officer before that?
Johnson C. Smith in Charlotte, which is a university, and Winston-Salem State, which is in Winston-Salem.
All right. While you were employed with North State Company Police, you were not also employed as a police officer anywhere, were you?
No.
Okay. Are there officers at North State who are employed as police officers and do some work with North State Company Police?
And there are some part-timers that was there at that time, but they wasn't working at the Guilford County contract. They were either called in for other stuff like special events or or provide security for clients. That was about it.
All right. You just mentioned a Guilford County contract. Is that what you said?
Yes.
And so is your understanding that North State Company Police had a contract with Guilford County to provide services? Is that right?
Yes, sir.
All right. So your employer was North State,
Yes, sir.
and that's a private company, right?
Yes, sir.
And you received a paycheck where you paid monthly?
Yes.
Okay. Your paycheck came from North State, didn't it?
Yes.
Okay. On February 4th, when you arrived at the health department to attend to Mr. Nelson, you were outside of the building for a period, right?
Yes.
Before you went in. And you had you turned on a body-worn camera you had on, right?
Yes.
You turned it on outside of the building.
No. Turn it on inside.
Inside.
Yes.
Did you see the video that was played of your body-worn camera yesterday?
Yes.
Did you not see any footage from outside of the building?
Yes. There's a 2-minute delay. It goes back 2 minutes once you hit record. So if you heard doot doot, that means I turned it on, which I did inside. So it switches back 2 minutes to outside.
Okay. So, but there was captured video from outside, right?
Yes.
And we saw it yesterday.
Yes.
And on that video, did you put on your gloves outside?
No, put my gloves on inside.
Put your gloves on inside? There was language you used. You said, this fucking clown. Do you remember saying that?
Yes.
All right. And you were referring to Mr. Nelson, right?
No, sir. We
No.
had another conversation.
That was another conversation?
Yes.
Okay. Who were you referring to when you said this fucking clown?
Not particularly remember, but me and Captain were having that conversation while still dealing with that.
Okay, you and Captain who?
Captain Daugherty.
You and Captain Daugherty were discussing something, and you referred to something within that separate conversation as this fucking clown.
Refer to whatever we were talking about at the time, while still waiting to get confirmation on what was going on inside. We're having 2 different conversations.
Okay. Because it sure seemed like you were referring to Mr. Nelson. Am I mistaken about that?
You are mistaken about that.
Okay. So you entered the building with your gloves off, right?
Yes.
And you saw Mr. Nelson standing there, right?
Yes.
You saw Captain Daugherty standing there.
Yes.
And you walked across the floor up to Mr. Nelson, right?
Walked behind Leslie and walked to the side of her.
Okay. And you put your gloves on when you were walking?
Yes.
You know Mr. Nelson can't see, right?
No, I don't.
You don't?
No.
You don't know that he's blind?
I'm not a medical doctor. I can't assume or not assume that he is or is not.
Okay. Did you see his white cane when you went in the building?
Yes, sir.
Okay. And do you know what white canes are used for?
Yes, sir.
Okay, there, by law, did you know that by law, it's illegal for anyone that isn't visually
Object
impaired
to the
to use a
legal
white cane?
conclusion.
Overall, okay.
Say that again, sir? Your question, there was two people talking.
You know, under North Carolina law, only a blind person can use a white cane. Did you know that?
Yes, I do know that, sir.
Okay, and you saw he had one,
Yes, sir.
but you don't know that he's blind.
No, sir. People have handicap stickers are not handicapped.
I'm sorry?
People have handicap stickers are not handicapped, so that don't mean because he has a walking stick means that he's blind. Like I said, I'm not a medical profession. I can't assume or not assume that he is or is not.
All right. Did you have any reason to believe he was not blind?
Not particular, because I wasn't there to assess his disability. I was there because we were called because he was recording and he was refusing to leave the building.
Okay. When you entered the building, did you announce yourself that you were there?
No, I did not.
Did you, when you walked up in close proximity to Mr. Nelson, did you identify yourself?
No, sir.
Okay. And at that point, did you have any reason to believe that Mr. Nelson, well, you didn't have any reason to believe that Mr. Nelson knew who you were at that point, did you?
No, because I wasn't speaking to him at that time.
Right. But you did eventually speak to him?
Yes, sir.
When you spoke to him, you said you have about 5 seconds to leave or I'm going to arrest you. Do you remember saying that?
I remember saying that was not our first initial words that were spoken to him.
Okay, what were your first initial words?
I asked him if he was going to leave the building because he was told numerous times to leave. Then he proceeded to repeat what he believed what the second-degree trespass was in his own explanation.
He told you he would leave, didn't he?
He said he would leave, but he wasn't leaving.
Right. But he said he wanted clarification from you, right?
Yeah, he could have clarification as we walked and talked and left the property like he was supposed to do.
So that's a yes. He asked for clarification.
He asked for clarification, yes.
Okay, did he ask who you were?
No, he never asked who I was.
He never asked who you were?
No, he just asked for clarification what he was being threatened with at the time.
Okay. So after you asked him, after you said you got about 5 seconds to leave or I'm going to arrest you for trespass, he asked for clarification, right?
Yes.
And he wasn't threatening you in any way at that point, right?
No.
He didn't seem angry?
No.
He didn't have a raised voice?
No.
And then you reached out and grabbed his wrist, right?
Yes, because I told him he was under arrest.
Right. But you reached out and grabbed his wrist?
Yes, that's how you arrest somebody.
Okay. And that's how you arrest somebody? Is that your testimony?
Yeah, you have to put hands on them to get a control of their wrist so you can apply the handcuffs. That's how you arrest somebody.
But you didn't have any reason to believe that Mr. Nelson at this point knew who you were, did you?
I would think if I said I'm going to arrest you, it's implied that I'm a police officer.
Well,
but that's neither here or there.
Right.
But no, he wouldn't.
But you weren't a police officer, were you?
I am a police officer.
Then you were not a police officer.
Then I was a sworn police officer.
But you were employed by North State Company Police,
And
right?
the key word is company police.
Uh-huh.
Yes, sir.
Sir, you just testified you were not employed by the city, the county, the state. You're employed by a private company, right?
That is governed by North Carolina. The General's Attorney's Office. Familiar with that? Yes.
The general's attorney, what?
The Attorney General's Office. I'm sorry.
You were employed by the Attorney General's office?
That's who powers company police. I'm pretty sure if you did your homework, you'll see that 74-E, if I'm not mistaken.
Okay. So you were employed by the Attorney General in North
No,
Carolina?
they give us the power to be sworn police officers. That's who we fall under.
Okay. But you didn't have any reason to believe that Mr. Nelson, you had not indicated to him that you were, in your words, a police officer, had you?
No, those are not my exact words.
Okay. You didn't say that you were police, did you?
No, those are not my exact words.
You didn't say you were an officer.
Those are not my exact words.
You said you got 5 seconds or I'm gonna arrest you. That's what you said.
Yes, sir.
When he asked for clarification, you didn't provide it, did you?
No, sir. It's not my job to clarify what he presumes it to be. My job is for him to leave the property like he was told. He could take that up outside, off of the property. We could have a lengthy discussion. We could go over Google, whatever he wants to do. We could get exact verbiage, but not at that time.
This body-worn camera you had on, it was on filming, correct?
Yes.
Okay. And that's not issued by, that piece of equipment was not issued by North State Company Police, was it?
No, sir.
Okay, you purchased that on your own?
Yes.
Okay. And you save the information you record on that video?
I save whatever's pertinent at the time to save space.
Right. And did you save, so you obviously saved the recording because we watched it yesterday, right?
Yes.
And where did you keep that? Where did you keep it up to yesterday?
I gave it to the DA's office when they asked for it, and it's usually kept at a work computer.
On a work computer?
Yeah, because I had a hard drive for the work computer.
Okay. Did the other officers at North State Police buy their own body-worn cameras?
There's a few that has purchased their own.
But it wasn't required?
It's not required.
All right. And did y'all have a policy there about keeping
No.
these saved videos?
No, sir.
Okay. But nevertheless, you kept it on a company hard drive?
It was my work computer at the time.
Okay. No further questions?
Thank you. Any redirect?
Just a couple questions, Your Honor. Deputy Boyce, were you employed as a public officer on February 4th, 2020?
As in public, as you mean a government officer or private officer?
Were you employed as a sworn law enforcement officer?
Yes, sir.
Okay. And did you have the authority to arrest people, to seize property, whatever you might have been able to do, say as a member of the High Point Police Department?
Yes, sir.
Your Honor, I object on relevance. You can't be both, and it's irrelevant because it just doesn't make any sense, and it should not be considered for that reason.
So noted, as far as your objection, overruled.
Thank you.
And what'd you do with the copy of the video that we watched yesterday?
Like I said, it was saved to my work laptop at the time, then transferred to a flash drive so I could give it to the investigator for the DA's office so he could put it on his laptop to make a copy.
And when you placed Mr. Nelson under arrest for second-degree trespass, did you place him under arrest because he was blind?
No, sir.
Did you place him under arrest because he had a disability?
No, sir.
Because he was a male?
No, sir.
And before you placed Mr. Nelson under arrest, did you tell him that you were going to put handcuffs on him?
I told him he would be arrested for second-degree trespass. He then tried to explain what it was. Then I told him he had 5 seconds to leave, or else I'm going to place handcuffs on him.
Do you recall if you had introduced yourself by giving him your name at that point?
I had not.
Okay. But when you told him that, did he respond to you?
Yes, he started to ask why he's being threatened with arrest, and then he started to clarify what second-degree trespass was.
So he acknowledged what you told him?
Yes.
Those are my questions.
Thank you. Any recalls?
No, Judge, thank you.
All right, thank you. You can sit down, sir. Are you under subpoena, Deputy Boyce?
Yes, ma'am.
All right. Any objection to him being released from his subpoena?
No,
If he so chooses?
No,
All right.
Judge.
All right, thank you. So Deputy Boyce, you're free to stay or leave. Thank you. Mr. DA?
That's the evidence for the state, Your Honor.
All right, thank you. Mr. Holt?
Judge, I'd like to make before closing arguments, I'd like to make a motion to dismiss based on the state's failure to put on evidence for each and every element of both second-degree trespass and resist public officer. And I will start with the I'm going to stick to the elements for my motion to dismiss. And the first point, Judge, I'd like to make, well, actually, before I do that, I'd like to point out that there is a severe variance between the evidence presented and the charging document, the magistrate's order taken out by arresting officer Boyce. The second-degree trespass on that charging document says that the defendant, Michael Nelson, trespassed at Guilford County Courthouse. And Your Honor heard testimony that this was at another location near the Guilford County Courthouse, but certainly not the Guilford County Courthouse. The Guilford County Health Department is where this happened. The resist arrest section of the charging document goes on in the same vein and says that he resisted arrest defendant was instructed to leave the premises and does not state what that premises was, leaving the reader to assume it's also the Guilford County Courthouse. It certainly doesn't say the Guilford County Health Department. And there was testimony that the Health Department is a distinct building from the courthouse, and that's general knowledge, Judge. Given that there is some room for variance between a charging document and testimony, evidence given at trial, we submit that location for a second-degree trespass charge is absolutely, has to be right. A defendant has to be put on notice how to defend their case. They have to be sufficiently noticed to develop a defense, as Your Honor knows. My questions at trial have revolved around what happened at the health department, simply because in real time the testimony was about the health department. I prepared for it to be at the health department, but it was a guess. I also know that Mr. Nelson, as Your Honor heard in testimony, has had run-ins with these folks in the courthouse. So he was not sufficiently apprised of the charges against him, and we contend that's a fatal variance. Your Honor, I have some more arguments more specific to the elements, if Your Honor is not persuaded by that argument. Second degree trespass. The elements require person is guilty of this offense if without authorization enters or remains on the premises of another after having been notified not to enter or remain there by the owner, a person in charge of the premises, a lawful occupant, or another authorized person, or if it's posted. There was a posting there. Mr. Nelson certainly couldn't read it. What he was told and what was said in the testimony, the first utterance that sounded like a request for him to leave was from Officer Daugherty, and it was, quote, stop recording or leave. And we submit, Judge, that has another side to it. That also means if you stop recording, you can stay. It's a conditional request. And there was no testimony, convincing testimony, that they had established at that point that he was still recording. The next request for him to leave was from Officer Boyce, and this one is interesting. This one says, Officer Boyce said, "You have 5 seconds to leave or I'm going to arrest you." He just testified to that. It is wholly unreasonable to charge someone with second-degree trespass if they don't have an opportunity to leave after the request is given. Not only that, but Mr. Nelson didn't know who was speaking to him. Nevertheless, his immediate response was, "Okay, I will leave." But I need some clarification. A simple, reasonable, direct question. That was met with someone reaching out and grabbing his arm. And we submit that he did not have the opportunity to leave. He was not given it. In the 5 seconds after since he first got a clear indication that he had to leave. And I'm going to talk more about that later. Your Honor, I'd like to submit a case, and this speaks to really all the elements, but really it speaks to without authorization element in second-degree trespass. It's State v. Markopoulos. I think I gave you a copy.
I got it.
I may approach.
Yes.
This case, in a nutshell, the most pertinent part of the case says that in a public place, this case was in a private building that had a public area. But the case says, and the place where Mr. Nelson was is even more public than that. It is a designated public building, public place. That someone must commit some act to void the implied consent to be in a public place. The case I handed Your Honor was in a private building, but they had a public lobby, and there was a number of young people had assembled in their lobby. And their lawyer, they argued at trial that they had a right to be there just because the security at that building didn't think they should be there. Doesn't mean they didn't have a right to be there if it's a public place. The court made clear that it requires to pass constitutional scrutiny. There has to be some act given that voids the implied consent that exists for everyone to occupy public places. The court ultimately did not rule in the young people's favor in that case. And the only reason is because there was a huge number of them, and there were so many of them that it was unruly. But extending the logic of implied consent and committing some act to void that, Mr. Nelson had a right to be in the public health department, and he had a right to not be assaulted and dragged out of there or wheeled out of there simply because he sought clarification. My guess is the state will argue that his alleged filming voided his implied consent to occupy a public space. But that argument is dead on arrival, Judge. It's a First Amendment protected speech to film in public places. There is some, we have constitutional scrutiny for a reason. That means that there is some line that can be drawn with respect to that, but we haven't confronted that here. We're talking about a criminal charge stemming from a constitutionally protected practice. And I might as well say this now, not to mention that the Officer Boyce was himself he's not a public officer despite his testimony. And I'm going to talk about that when I get to the resist. But private police aren't public officers just because they have police in their name of the company. That doesn't mean they're public officers. I mean, like fifth graders might think like that, but adults don't. Just because you have a name, you're called a police officer by a company. He testified he's not employed by the state. He's not a public officer. He is now, but he was not then, and that is for sure. He was filming with his own private camera on his own GoPro and arrested this man for doing the exact same thing, as if what he was doing was illegal and what he was doing was legal. Mr. Nelson's the only one that got assaulted by someone who was breaking the exact rule he accused him of breaking. Filming.
Closing argument versus a motion.
I'm sorry, I'm getting carried away. I'm going to move on to resist, Judge. Thank you, Your Honor. The resist. Willfully and unlawfully resist, delay, obstructs a public officer knowing or have reasonable grounds to believe that the victim is a public officer. Okay, well, there's two elements there that we don't have. The first one is a public officer. It has to be a public officer by statute. What's a public officer? Well, it's not private security. I have a case, State v. Farabee, If I may approach, Judge, I've already provided
Yes.
one to the state. State v. Farabee sheds some light on this issue of what exactly is a public officer. In State v. Farabee, Judge, there was a man in Durham who the authorities were looking for. I can't remember why. But the authorities were looking for him, and a security guard at Duke Hospital saw him and said, "Hey, stop." Recognized him, said, "Hey, stop." And the man took off running. Security guard starts chasing him. Campus police officer joined the chase. Says, "Hey, stop." They eventually catch the guy. He's charged with resist arrest. And he argues at trial, private security was the first one that told me to stop, so I wasn't resisting. The Court of Appeals, however, pointed out the obvious fact that this is where they distinguish public officers, campus police, from security. They said, well, he told you to stop, the security guard, but you resisted arrest because you weren't arrested by private security. You were arrested by campus police, and they're police officers. They're police officers, sworn police officers. So their reasoning is, it is a resist because it wasn't private security that arrested you. It was an actual police officer. They don't go as far as to say outright, if you'd only been arrested by private security, it wouldn't be a resist, but that's clearly what they mean. And it's a fairly short case, Judge, if you'd like to read over it. The second half of it's about Crawford, and that part isn't relevant to what I'm discussing.
Did you have any other argument?
Yes, Judge, with regard to the fourth element of release, delay, obstruct is knowing or having reasonable grounds to believe the victim is a public officer. In this case, they didn't even get there. Officer Boyce just testified that he did not identify himself to Mr. Nelson before he took him into custody. That's as clear as it could be. And we saw in the video that he identified himself after Mr. Nelson was on the ground, after Mr. Nelson was handcuffed. We saw in the video that Mr. Nelson was begging for him to identify himself over and over. Who are you? Who are you? Why are you doing this? Who are you? And Officer Boyce never did it. Mr. Nelson is blind. He had no idea who he was, who Mr. Boyce was. None. Could have been anybody. And I would point out that I'm assuming, I would guess Your Honor is a faster reader than I am, as most people are. But I'd like to point out the paragraph in the case, State v. Barbee, which states, it's just before the part, it's the last paragraph about public officers before the hearsay argument begins. It's at the top of the page.
I've already got it.
Okay. Where it quotes State v. Taft, where it states, yeah, some people that aren't police officers are public officers, but they're always employed by the state. They list alcoholic beverage control officers and, well, that's it. Thank you, Judge.
Thank you, Mr. Holt. Mr. Diaz, did you wish to respond?
Briefly, Your Honor, I ask that you deny the defense motion to dismiss at this point, taking everything in the light most favorable to the state. I think that the state has satisfied each element of each offense. I'll get to that in a minute. To address the alleged defect in the charging document first, I would argue that the charging document is sufficient. I think it has put Mr. Nelson on notice of what he's charged with, the date and time, where he's charged with. Again, there's videos of this. These videos have been public. But if Your Honor is not satisfied that he had sufficient notice, again, the state can request to amend the charging document either by amending the magistrate's order or substituting it with a misdemeanor statement up to the point that Your Honor enters a final judgment. So I think we're still at an appropriate time to do that. If the court thinks it needs to be amended to say specifically the Guilford County Health Department. But given the evidence that you've heard, given everything that's been produced, I think he's been put on notice of where he was trespassed and the reason for his RDO. So I think there was sufficient notice. I'd ask you to find that there is not a fatal defect on the charging document. But if the court is not satisfied that there was notice, I'd ask permission from the court to amend either the order or substitute it with a misdemeanor statement of charges, specifically stating the Guilford County Health Department as opposed to on the premises of Guilford County. That would be my first request in response to Mr. Holt's motion to dismiss. Again, I won't belabor the motion at this point, but I would just argue to the court, I don't think there's any doubt that it's the defendant is the one who has acted or perpetrated the offenses that have been on trial before the court. No doubt as to the jurisdiction. If I may approach, I'll go ahead and hand the court this case. I think it speaks to one of Mr. Holt's arguments as to the second-degree trespass.
Yes.
Specifically on the persons in charge or persons with authority to trespass or remove somebody from property. And this is State v. Mickens. State v. Mickens also cites the case that Mr. Holt handed up, Macropolis. With this, I think that you've heard from three people who undoubtedly had authority or held authority to remove Mr. Nelson from the premises. The first being Ms. Barbee. I'll just remind the court that she was the building manager. The second being Captain Daugherty, the head of security here in Guilford County at the courthouse. and the other county buildings. And third, Mr. Boyce, Deputy Boyce. Again, Deputy Boyce did not refer, or Deputy Boyce, having been a sworn law enforcement officer
No, I'm
at that.
sorry, I object, it's more variance. The warrant says it's from Captain Daugherty, who told him to leave. And he's reciting other people.
I would like to see these trespass warrant.
Yes, ma'am.
Okay.
He was told by 3 people to leave. You heard that during their testimony. I don't think any of that was contradicted, impeached in any way that they told him to leave or stop recording. So, and I would argue that all 3 of those individuals had authority to tell him that and to try to remove him from the building. He did not leave. He did not leave. Instead, he remained. So, having satisfied those elements, I would say that in light most favorable to the state, there is sufficient evidence to proceed at this point. And again, on the RDO, if the issue is the element requiring Mr. Nelson to believe or reasonably believe that a law enforcement officer or public officer was telling him to leave or he would be arrested at that point, based on Deputy Boyce's testimony as well as the video, Deputy Boyce did tell him that he was going to place him in handcuffs, he was going to place him under arrest. At that point, you heard his testimony, you saw it was on the video. Mr. Nelson acknowledged that. I think arguably when he acknowledges that and he continues to try to ask him or argue with him what second-degree trespass is, at that point he does acquiesce that he is talking to somebody who does have the authority to place him under arrest. So I think that element is satisfied. Referring to the crimes book and also State v. Farabee, the case you were handed up for Mr. Holt, I think that Deputy Boyce would satisfy a public officer under the elements and under the language referred to in the crimes book. Again, State v. Farabee, it's about campus police officers. We'll say that's his equivalent. No, he's not a police officer employed by the city or employed by the county. Neither is a campus police officer at Elon or Campbell or any other private university in the state, but according to this case, they still have the authority to arrest somebody and are still considered a public officer. Deputy Boyce testified to you that he was a sworn law enforcement officer, and under the crimes book, I'm quoting, it says, the statute's broad language may prohibit resistance toward any public employee who is required to regulate the conduct of others, such as a firefighter or a building inspector. His position as a company police officer here at the courthouse, that required him to regulate the conduct of others. Again, he was a sworn law enforcement officer. He testified to you that he was a sworn law enforcement officer. He testified to you that he had sworn law enforcement officer training at that period in time. Again, so he is a public officer. He is someone who's qualified to make an arrest under the statute and under the case that Mr. Holt handed to you, under the language that's cited in the crimes book that's referred to by everyone that works in this courthouse. So those are the 2 points. At this point, again, I think there is sufficient notice in the charging document. If the court determines there's not, state would ask to amend it either on the document or by misdemeanor statement to include the public health department, as well as he was trespassed by Miss Barbee, Captain Daugherty, and Officer Boyce. You heard all of that testimony yesterday. And I'd ask you to deny the motions to dismiss based on the insufficiency of the elements. I do think there is sufficient evidence for each element of each crime that Mr. Nelson's charged with.
Thank you. I would like to hear from you, Mr. Holt. I'll give you, this is unusual, I understand. I want to hear from you with the state's motion to amend the second-degree trespass warrant to reflect not the courthouse, but the building next to it, the health department. Would you like to be heard on the state's motion to amend?
Yes, Judge.
You go ahead.
We oppose that motion. And we submit that's a substantial alteration to the warrant. And we say that because location is an element of second-degree trespass. A substantial alteration is the standard for an amendment after the first witness is sworn, as Your Honor knows. I keep this handy-dandy laminated thing from a public defender that I look at every time this issue comes up. A substantial alteration is such if it alters the elements of the crime alleged. This certainly does. A second-degree trespass is absolutely dependent on the location where the person was. Guilford County Courthouse is not the Guilford County Health Department. There are different environments with different people. The defenses that could have been raised are different at each location. But the bottom line is it speaks to an element of the crime. And the resist comes from the second-degree trespass. The resist, there is no resist if there's no second-degree trespass. So we oppose on those grounds an amendment to change the language for either charge, as its substantial alteration would be required, Your Honor.
Thank you.
Maybe heard briefly.
Yes.
So, just pointing to the statute, substantial alteration.
Which statute are you referring to?
15A-922.
Subsection F.
Subsection F. An amendment's proper as long as it doesn't change the nature of the offense. I would argue that doesn't change the nature of the offense. Nothing's being changed. Date, time, anything like the individuals work at all of these buildings. Again, he's still put on notice of where he's being trespassed. But I don't think that changing it at this point would alter the nature of the offense. He's being trespassed from a Guilford County property. Again, the warrant doesn't specifically state which one, but I would argue that it's not changing the nature of the offense.
Thank you. All right, in reading North Carolina General Statute 15A-922 subsection F, all right, it does in essence state that it looks like a statement of charges, criminal summons, arrest warrant, citation, or magistrate's order may be amended at any time before or after final judgment, so long as the amendment does not change the, quote, nature of the offense charged. Also, it points, I see reference to North Carolina General Statute 15-24.1, which talks about amending ownership. The state can make the amendment either by moving to amend the original pleading or by replacing the original pleading with a misdemeanor statement of charges. See State versus Caps 374, NC 621, and that was a ruling from 2020. Let's see here. In State versus Grady 136, NC App 394, decided in 2000, amending an address of a dwelling in charge of maintaining a dwelling for use of a controlled substance was allowed. The state generally has been permitted to amend the indictment, that was a Superior Court case, to correct the location where the offense is alleged to have occurred. in State versus Snyder, SNYDER 343 NC 61, decided in 1996, amending habitual impaired driving indictment to include, quote, public vehicular area, end quote, in addition to street or highway was allowed. In State versus Hyder, HYDER 100 NC Acts 270, decided in 1990, changing the name of a county in an indictment was permitted as an amendment. However, a motion to amend is not allowed if the amendment constitutes a, quote, substantial change, end quote, to the indictment or charging document.
Your Honor, if I may.
Well, no, because this is time for me to rule on that issue. So give me just a minute, let me look. Continue to look. Then if I have questions or anything, I'll come back to you, okay?
Okay, Judge.
So that y'all aren't having to sit here and wait on me, let's just be at ease for about 10 minutes while I continue to research this issue. So if anyone needs to go to the restroom or step outside, you're more than welcome to do so.
Second session.
All right, thank y'all. Okay, with respect to resist, delay, and obstruct, motion to dismiss is denied. And with respect to the second-degree trespass, I am going to allow the state to amend the warrant to reflect the accurate location versus the courthouse, it being the health department next door to the courthouse. And I will note, Mr. Holt, when you indicated that you did prepare your case on behalf of Mr. Nelson, with the date of the case being at the courthouse, at the health department on that given day, and you assumed that it was the health department, that indicates that the prejudice is just simply not there. So I am
Judge,
going
that's
to
not how I intended that to be interpreted.
Okay.
I was saying I guessed it could be that, but I didn't know. I
You said you
also,
prepared for it to be at the health department, and you assumed it was the health department,
but I didn't.
but you weren't sure. That was what
No,
you
I was not sure, and I only,
Okay. Well, my rulings remains the same.
right, but I also, and that's not the standard. The standard is whether he was apprised by the warrant. I guessed, but I could have been wrong.
So what
I
I'm going
also
to do
guessed
is
that
this.
I also prepared.
Listen to me, Mr. Hall.
Yes.
I'm going to grant the state's motion to amend, but what I also think would be proper and appropriate is to allow the defendant, Mr. Nelson, statutory time period to prepare any differently, with it being the location of the health department. And I will continue the case out for hearing in order to grant that notice unless Mr. Nelson waives that time period of notice, and we will proceed. Otherwise, we will continue it out and we will pick a date.
Understood.
If you need time to talk to Mr. Nelson about that, you're more than welcome to do so.
Well, Your Honor, jeopardy is already attached on, it's been tried. Jeopardy attached when the first witness was sworn.
So
I think at most at this point, the judge could recharge him. And then there'd be another jeopardy question would arise then. But as of right now, the case has been tried under the facts that the state wanted to try it. Jeopardy is attached, and we can't
You can certainly make
retry
that
it.
argument, but my ruling is I'm allowing the state to amend. So, if there's any additional evidence, or any evidence that you wish to present based upon that, I am allowing the state to do so. So, do you want to speak to your client if he would like to waive any type of notice to that amendment, or if you would like to proceed?
Yes, Judge, I would like to speak to him.
Okay. And you can remain here, or, I don't know if that's a side room or not.
It is.
You can go in a side room, or you can step outside the courtroom, whichever you prefer.
We're going to step into the side room, Judge. Thank you.
I'll make it, but unlock it. I'll make it.
Appreciate that.
Yes, Mr. Cole.
Thank you, Judge. After conferring with my client, we did not request 3 days offered. However, we would submit that the state has rested their case, and despite the amendment, cannot put on more evidence subsequent to that.
I'm sorry, say that one part, the state's rested, so you're
The state is
waiving the
rested.
statutory notice? Is that what I heard? You're waiving the notice, the 3-day notice?
That's right.
To the amendment?
Um,
Is that correct, Mr. Nelson?
I'm sorry?
Are you waiving your right to 3 days notice of the amendment?
I don't really understand what that means.
Okay.
And we would submit that the 3 days notice applies when a motion to amend is made prior to trial.
Okay. And there's some case law that I read that indicates that sometimes notice isn't required, but you are waiving any notice in preparation, is that correct?
We submit that that notice provision doesn't apply because it has to be made before trial in order for that, because we've already had the trial. We can't waive notice and take 3 days retroactively.
All right. knowing that I am allowing the amendment, are you asking for any additional time to prepare for this case?
No, Judge.
All right, thank you. All right, with the amendment then, defendant's motion to dismiss is denied. All right. So, Mr. Holt?
I think it has to be in writing, Judge. Is the DA planning on submitting that in writing?
I can print out a misdemeanor statement right now. So,
Well, it will include the same file number and the same charge, but different building.
We would ask for that, Your Honor.
Okay.
and that language would just be, I, the undersigned, upon information and belief, alleges on or about the dates of offense shown. And in the county named above, the defendant named above did unlawfully and willfully and without authorization enter and remain on the premises of Guilford County Health Department located in High Point, North Carolina, next to the Guilford County Courthouse after having been notified not to enter or remain there by a person in charge of the premises, Captain Daugherty with Guilford County Security.
Go ahead and print that out. Can you print in this courtroom, Mr. DA?
I don't believe so. Maybe quicker. Madam Clerk, can you print in here?
I don't have anything up.
Can I email it to you and?
Yes. Let's do that. Clerk, do you have anything to add, Steve?
So only if I did, we did very peaceful.
All right, are there any questions about the process that's just occurred? Mr. DA, Mr. Holt?
No, Your Honor.
I think I've aired all my, objections and questions about it, Judge.
Okay, thank you. All right, Mr. Holt? Ready to proceed?
Yes, no evidence for the defense, Judge.
All right, thank you. Are y'all ready to proceed with closing arguments?
Yes.
Yes, ma'am.
All right, Mr. DA?
Thank you, Your Honor. May it please the court, Mr. Nelson, Mr. Holt. Your Honor, I'll keep this brief. The first question is, why exactly are we here? Having to try and anticipate what Mr. Holt would argue, I assume that it would be a First Amendment issue. If I may approach, I've got a couple of cases that I would submit to the court that the state contends provides good guidance on these matters. I've got copies for Mr. Holt as well.
Have you received your copy, Mr. Holt?
I don't know.
The first is Benzing versus North Carolina. The second is Hodge versus Board of County Commissioners. Both are cases decided in the Fourth Circuit Court of Appeals, specifically advising or holding on the issue of cell phones in public property or in government buildings. Just so the court's aware, Hodge v. Board of County Commissioners is a fairly short case that originated out of a Maryland Federal Circuit Court. It was then appealed to the Fourth Circuit Court of Appeals. Fourth Circuit Court of Appeals affirmed the lower court's decision, dismissed both of the plaintiff's claims in that matter. Would just point the court's direction to the initial case, again, that was affirmed from the lower court, its guidance on cell phones. In that case, quote, cell phones can be used to photograph and or record closed or sensitive proceedings for unlawful purposes, and the prohibition of cell phones in courts and public buildings is a common precaution. No First Amendment right to communication guarantees a right to carry cell phones in government buildings. Hodge does not elect that the cell phone prohibition was intended to chill or in fact chill constitutionally protected free speech. The court also points out that the plaintiff in this case, or Hodge, was inconvenienced, perhaps uncomfortable with the security measures. However, they did not find that they were so grave that they violated his constitutional right under the First Amendment to take pictures or to video record public areas or areas that would be in plain view of what you're recording or videotaping outside. And again, the other case that I've handed up on that issue is Benzing versus North Carolina. That is a federal case out of the Western District in this state, still under the Fourth Circuit. But it also addresses a First Amendment issue with cell phones and government property, as well as public buildings. That would be on page 5 of the holding that I provided to the court, that language that specifically addresses that there is no First Amendment issue with restrictions on cell phones or on recording devices in public places or in government buildings. So first point would be that that's not why we're here. This is not a First Amendment issue. The restrictions on cell phones inside the health department, inside the courthouse, again, these cases support that there is no unfettered right under the First Amendment to carry your cell phone into a government building or into a courthouse, into a health department in this case. And I think Ms. Barbee's testimony illustrated why that is a reasonable restriction. She told you that there were people in there, coming in there under what they expected to be anonymity. People come in there to receive care, not wanting other people to know that they're coming in there. People are coming in there with sensitive medical issues that they don't want other people to find about. And again, they're going to the health department because there's some level and there's some reasonable level of an expectation that they're anonymous when they come in there. It might be a minor child or, you know, a teenager coming in there for something that they don't want to have to disclose to their parents or someone else, and that's why they're going in there. That's why those restrictions are in place. Those policies and those protocols are applied to everybody coming in and out of the health department. Again, Ms. Barbee illustrated that. Ms. Barbee told you that. She also told you that as long as she's been there, there have been people who have come in with disabilities who have had to have their disabilities accommodated. And I believe her testimony was that she couldn't recall an instance where that accommodation had been denied. Now, in this case, with Mr. Nelson's accommodation, again, trying to anticipate what will be argued in this matter as to why he's not guilty of first-degree trespass or resisting a public officer.
You mean second-degree trespass?
Second-degree trespass or RDO. I can anticipate that there will be some argument of the First Amendment, which again, I'll just point to those cases. I think that's settled. I think that issue is settled. I disagree with the notion that it's dead on arrival. I think that it's very much alive and well, that it's understood that there can be reasonable restrictions and limitations placed on your ability to carry a cell phone or to carry something that records inside a government building, health department, courthouse, whatever it may be. However, Ms. Barbee told you that there are policies in place, there are protocols in place. She was unaware of any time that anybody had ever been denied an accommodation, and that's not what's happening here. Mr. Nelson, just for today's proceeding, he was given a reasonable accommodation. However, he chose not to accept it. That's not the health department, that's not the courthouse denying him a reasonable accommodation. That's the courthouse or that's the health department saying that this is a compromise, this is where we're meeting you. However, it's not an infringement on First Amendment. It's not an ADA violation for the court or the county health department to restrict his recording devices in there and try to grant him an alternative way to come in there with other things other than exactly what he wants or what he feels like he needs to have when he goes in there. Again, that's just my anticipating what you might hear to try and persuade the court why he is not guilty of second-degree trespass as well as RDO. I presume that the court's going to hear that he's not guilty, again, because his constitutional rights were violated or his ADA rights were violated. However, I don't think you've heard any evidence of that. I think that the evidence that you've heard suggests that he came in there. More importantly, this is not the first time he's been in either one of these buildings. Ms. Barbee, Captain Daugherty, as well as Officer Boyce, each told you that this was the second or third time that they had interacted with Mr. Nelson. Now again, going to the elements of second-degree trespass, he has to have notice. He can't read the signs that are posted in the parking deck or on your way up to the building. And it might be different if this was his first time trying to come in that building with that equipment. However, it's not. at least on Miss Barbee's account, it's the third time he's tried to come in there with his recording equipment. So if the court is asking whether or not he had sufficient notice that he could not lawfully be there with that equipment, the answer is yes. As far as whether or not he was told to leave by a person with legal authority, again, referring back to that case, Mickens, the holding in that case says that the definition of legal authority or a person in charge is not addressed by case law or statute. The case cites Black Law Dictionary charge is defined as a person to entrust with responsibilities or with duties. Again, I would argue to the court that Miss Barbee is a person in charge. She is the building manager. Captain Daugherty is a person in charge with the ability to tell people they can leave, they need to leave, or they can remain on the property. And again, Officer Boyce is a person in charge. He's a sworn law enforcement officer. He was working in that capacity on February 4th, 2020. And in that capacity, he could tell Mr. Nelson that he was not free to remain in that building if he chose to continue recording. Another issue is, well, what was the purpose that he was there for? Did he have a legal purpose to be there? Ms. Barbee told you that he had not, he was never a patient in that building. And I think the testimony that you heard from her, as well as Officer Boyce, would suggest that Mr. Nelson did not have a purpose in that building, to receive medical treatment. What he was there to do was cause a confrontation. What he was there to do was make a scene. How do we know that? Because two people told the court that before they encountered him, they looked up online on his YouTube page that he's already recording being in there. Again, that is directly against the policy. The policy applies to everybody, whether they're completely able, whether they're disabled and have to make some sort of other accommodation. The policy is the same across the board. You can't have a cell phone in there, and you especially can't have a cell phone that's recording and live streaming to a YouTube channel. Again, Ms. Barbee talked to you about why that policy is in place, why that protocol is in place. It's in place to protect the patients who are coming there to receive treatment, again, who expect that they're going in there under some sort of conditions of privacy or anonymity. They're not going in there expecting and wanting to be live streamed on YouTube to whoever's watching these videos. So again, I would submit to the court that the evidence overwhelmingly shows he is not there to receive treatment. He's not there for any other purpose other than to cause a confrontation and to cause a scene. And again, how do we know that? It's already online when they encounter him. Ms. Barbee told you that. Officer Boyce told you that. Neither one of their testimony was impeached. Neither one of those witnesses' credibility was called into question. There's absolutely no reason to doubt that information. As to the RDO, briefly, Mr. Nelson is being placed under arrest for second-degree trespass. And again, his trespass has nothing to do with his disability. It has nothing to do with his sex, with his gender. That's questions that I asked two witnesses. They specifically told the court he was being asked to leave because he brought a prohibited device in there, and he was using that device to live stream and record. That's why he was being trespassed. He's not being trespassed at all for any basis on his disability, on his gender, on his race, or any other reason other than he's coming in there with a prohibited device and he's coming in there to record. So Officer Boyce places him under arrest at that point for second-degree trespass. And again, just quickly to address the two issues with the RDO. One of the elements, I believe it's the third element of RDO, requires that the defendant be aware that the victim is a public officer or reasonably should know that the victim is a public officer. In this case, I would go back to the video, I would go back to Officer Boyce's testimony. that Officer Boyce is the third person that comes into contact with him after he's been approached by Miss Barbee and Captain Daugherty. Officer Boyce told you that he walks up on the scene or walks up where they're gathered. When Miss Barbee's talking to him, he overhears her tell him she needs to leave. Captain Daugherty tells him he needs to leave in Officer Boyce's presence. He testified to that. That's on the video that everybody saw. And then Officer Boyce is the last person that tells him he needs to leave. Now, the point in time that Officer Boyce, or Deputy Boyce at this point, places cuffs on Mr. Nelson, he's already put himself on the ground. And then he lets him know that he's Officer Boyce with North State Police. However, the state would say that arguably Mr. Nelson was aware that the victim or the person in this matter that arrested him was a public officer with that capacity, because he was told, if you don't leave, I'm going to put the cuffs on you. You've got 5 seconds to leave before I put cuffs on you. Or he was going to place him under arrest. I believe he also said something on the video. I've noted during that exchange, he told him that you're going to jail or something like that. And again, based on the video, he's the only one speaking to Mr. Nelson at the time. There's no one else talking except for Mr. Nelson, who's trying to talk over Officer Boyce and trying to get him to explain or clarify what second-degree trespass is. So at that point, once he acknowledges that Officer Boyce has told him he's going to apply handcuffs, he's going to restrain his freedom and his liberty to move, once he acknowledges that, I would say to the court that that is an acquiescence, that he is in fact talking to someone who can place him under arrest. He reasonably knows at that point that he's talking to a public officer, or he's talking to somebody who can place him under arrest and who can transport him to the jail. So that element of RDO is satisfied, would be the state's position. Whether or not Officer Boyce is a public officer under the meaning of the statute, I would argue to the court that yes, he is. Again, citing Mr. Holt's own case, I would point out that that officer in that case is employed by Duke University. That's not a public state university. That person is unemployed by the state. I don't know that that case explains that that person is employed by the state. If anything, I think it would be similar to what Officer Boyce testified to, that that person works for Duke University, contracted out by Duke to run their security. Same thing with Officer Boyce. He's operating on a contract through Guilford County to do police work at the courthouse. That's what he testified to. Under that case, under the definitions that are given in the crimes book, I would say he undoubtedly qualifies as a public officer with someone with the authority to make that arrest. So I would argue to the court that the elements of RDO are satisfied. With resist, delay, and obstruct, I think that Mr. Nelson's actions were certainly willful, and they were unlawful. He did, without a doubt, delay, resist, and obstruct Officer Boyce after he was trying to place him under arrest for second-degree trespass. I think the evidence is overwhelming. Everything that you heard to as far as the testimony and what you saw in the video. We sat here yesterday for 15 to 20 minutes while they struggled to get him in a wheelchair and get him over to the magistrate's office. 20 minutes, that's a delay. That's an obstruction. There's two of them working at one time is what he testified to. That's 20 minutes that if an emergency happened or if something else happened that needed his attention, he can't respond to it. Again, because Mr. Nelson is lying on the floor, is refusing to assist in any way to get up into a wheelchair, and is hollering out at that point for an ADA compliance officer or somebody over at the health department. Again, what I believe he called out for at the health department was ADA compliance officers. He didn't call out for somebody to check on his medical injuries. He kept saying, I'm hurt, something like that. But he didn't call out a doctor. He didn't call for anybody to assist him. And that's important, again, because the evidence that we heard from 2 witnesses shows that this is already recording when he's contacted by Miss Barbee and Mr. Boyce. Again, why are we here? We're not here to discuss the First Amendment. Again, I think those cases clearly show that that does not apply. I think any argument that you could hear that this is some sort of discrimination in opposition of the ADA, I don't think that applies. I don't think, well, you've not heard anything to suggest that at all. All of the evidence that you've heard from every witness that's testified is that Mr. Nelson was confronted because he was recording, because he did not articulate a reason to be there to anybody that he came in contact with, and he was trespassed for that reason. Again, he's not being trespassed, he's not being singled out on some discrimination of disability, race, origin, or anything like that. So in anticipating what you might hear, I would ask the court just to bring the focus back on why are we here. We're not here because of Officer Boyce. We're not here because of Miss Barbee. We're not here because of Captain Daugherty. They're just 3 people trying to do their job, and I think that day their job became a little more than what they thought it would when they came into contact with Mr. Nelson. We're here because of Mr. Nelson's behavior that day. At some point along the way, I think Mr. Nelson has determined that he does not have to follow the rules that are in place for everybody that goes into the house, to the county buildings, health department or the courthouse. He's been here 3 times. He knows what he can and cannot bring in. And again, he knows what he can and cannot bring in, even when officials try to extend a reasonable accommodation. And again, why does he not follow the rules? Because if he doesn't follow the rules, he can make a confrontation. When he makes the confrontation, it makes a scene, it creates a scene. And when it creates a scene, that's when you get thumbs up. That's when you're liked. That's when you get views. And that's when stuff goes viral. And I think that's, that's what it is here. All of the items that were inventoried by Officer Boyce, he had 2 phones, a camera, keyboard, recording equipment in his backpack. He went there, he's got that equipment, he's already recording. He's going there to make a scene. Again, he's going there for the audience that is watching during that live stream. That's why we're here. And I would say to the court that you're not going to hear anything that would create a reasonable doubt as to whether he trespassed that day or whether he resisted, delayed, and obstructed Officer Boyce while he was trying to arrest him for trespass, or while he's trying to transport him from one place to the other, while he's trying to get him up off the floor in front of the pharmacy window, while you still got patients going back and forth trying to avoid the scene over at the courthouse. Again, he's there to make a scene. He's there for his audiences watching. And again, I think that you can be totally and completely satisfied in the evidence that has been produced that he was in fact guilty of second-degree trespass and RDO. I'd ask that you find Mr. Nelson guilty.
Thank you, Mr. Diego. Mr. Cole, would you like to be heard?
Yes, Judge, thank you. Your Honor, I think the state's lengthy discussion about the First Amendment is telling, as that is not the crux of our defense. However, the First Amendment is important in this case. And, it may be that a court would rule that he had a First Amendment right to record in that building. I don't know how a court would rule on that. I have a feeling that it's probably okay. But I don't know. What I do know is that he had a right to try to discuss what was going on and what the officers thought he was doing with the officers that day. He had a right to ask questions. it has long been the law in North Carolina that people can't be arrested for remonstrating an officer. You can't be arrested for asking questions. That's not illegal. And I want to clear up something about this Farabee case, because Mr. DA's brought it up a couple times that his claim has been that Farabee equates campus police officers with security guards. It does not say that at all. In fact, Farabee distinguishes campus police officers from private security by citing a special statute called the North Carolina Campus Police Act, which grants by statute campus police the same authority as city police. So the case actually does the opposite of what Mr. DA has alleged it does twice, in both in response to my motion to dismiss and in his closing. And that's not true. That's not what the case says. Before I forget, I'd also like to renew my objection to the misdemeanor statement of charges. We contend it is a fatal variance, and I renew my prior comments about that, and I'll move on from that now, Judge. The first time anyone told Mr. Nelson that he needed to leave the health department was when Officer Boyce gave him 5 seconds to leave. Officer Daugherty previously told Mr. Nelson, turn off, stop recording, or leave. Mr. Nelson's response to that was not to rush Officer Daugherty. It wasn't to go in deeper to the place. It was simply to go to ask clarifying questions in a peaceful way. There's no requirement of second-degree trespass that you have to immediately run out if you pose no threat. There's no violence. He was being completely reasonable and tried to talk to them. And that is okay. That is lawful. I don't think he was trespassing. Even if he was, you still get to ask questions. You get to ask questions while you're being dragged out. You get to ask questions before you get dragged out. None of that is unlawful. What is unlawful is for an officer to say, you got 5 seconds to leave or I'm going to arrest you. And then the person goes, but I need clarification. Boom, then it starts. That's not lawful. That's illegal. And I haven't even gotten to the part that he's not a cop. He's not a police officer. He's hired, works for a private corporation. He is not a police officer. He is not a public officer in the statute. Nothing says that in North Carolina law. Not a single case or statute, nothing. All we have is evidence to the contrary. That contrary evidence is in the case that I handed up. That distinguishes private security guards from actual police officers. They distinguish private security from campus police and then cited a special North Carolina statute that gives campus police the authority of regular city police officers. It doesn't do it for private security. I apologize for speaking so broadly, but private security anywhere in America, we don't have to submit and be arrested to people that work for a corporation. We got to submit to the police because we have constitutional protections from the state that we don't have from corporations. That's why it has to be sanctioned by the state. It has to be, people have to be employed by the state. North Carolina has defined public officers as people that are agents of the state. And private contractors that have business with the state or are contracted to perform certain things for the state, that does not mean they are state actors. In fact, there is a mountain of litigation about that. But I don't need to go down that rabbit hole because North Carolina has been very clear in its case law to distinguish public officers from non-public officers. And I've given the court that information. In order for someone to trespass, to be guilty of second-degree trespass, they have to remain on the property they've been asked to leave. He was given 5 seconds. By the officer's own testimony, he gave him 5 seconds. And Mr. Nilsson didn't even know who was speaking to him. The officer that gave him 5 seconds testified, "No, I didn't identify myself." And then I asked him, "You did eventually, but it was after you had him handcuffed on the ground." "Yep, that's when I identified myself." I think that fact speaks to the resist, but it also speaks to the second-degree trespass. Also, Mr. Nilsson is blind. He can't see what's going on around him, obviously. But you saw in the video, there aren't just 3 people speaking to him at the same time. Of course he's going to seek clarification. He wanted to be there. He wanted to do something at the public health department where he had a right to be. And these people were trying to prevent him from doing it. Mr. Nelson's response to that was to peacefully seek clarification. That's what he's guilty of. He's guilty of peacefully seeking clarification. He is not guilty of trespass. He's not guilty of RDO. He's not a police officer. And the law says he's not. Thank you. Nothing further, Your Honor.
Thank you, Mr. Hall. Mr. Nelson, would you stand, please? All right, Madam Clerk, in 20 CR 67643, count 1, on a plea of not guilty to second-degree trespass, enter a verdict of guilty. With respect to count 2, on a plea of not guilty to resisting a public officer, enter a verdict of guilty. Let me just add a couple of things. With respect to, there's a difference as far as a private security person in that argument versus a company police officer. that does have the same statutory authority as was testified to by Deputy Boyce with respect to the Attorney General's office certifying those agencies, company police, campus police, as agencies to act as law enforcement agencies. I will say this, even if I gave some, you okay there, Mr. Holt?
My glasses are fogging, but I can see you through them.
You're okay?
It's from my mask. Yeah, I'm fine.
So I will say, although Officer Boyce did not identify himself to Mr. Nelson, I will say this, initially, he did indicate he would place him under arrest. However, at a later point in the video, which was more compelling for me, when Officer Boyce at that time, and I say Officer Boyce because you were an officer at that time versus deputy at this time, Officer Boyce, or Deputy Boyce, at the point where he did identify himself, Mr. Nelson at that point did not comply with the commands of the officer as he was trying to, as Officer Boyce was trying to conduct the business at that point. So, that being said, it will be guilty to both counts. At this point, Mr. DA, can you tell me please what record level Mr. Nelson is?
He's a record level 1. I don't need to be heard on the sentencing.
All right,
If Your Honor thinks it's appropriate for PJC, state's not going to oppose, but he's a level 1. I don't need to be heard any further.
Okay, thank you. Mr. Holt, would you wish to be heard?
He's a level 1 judge. We oppose the PJC.
You oppose the PJC?
Yes.
Okay. All right. I will enter my judgment, and then obviously your client and you on behalf of your client have a right to give any notice of appeal that you deem appropriate, okay? All right, Madam Clerk. And count 1, second degree trespass, again, let me actually start with the resisting officer. Class 2, level 1, I am going to sentence Mr. Nelson to 30 days in the custody of the Sheriff of Guilford County. I will suspend that sentence. I am going to place Mr. Nelson on probation for a period of 12 months. I will specify in a moment whether it's supervised or unsupervised. 12 months under the following terms and conditions. 1, in that matter, Mr. Nelson, you will be required to pay a $500 fine. And I am going to order that you are to obtain a mental health assessment, evaluation, and comply with any recommended treatment. You know what, and as a result of that, so I want to ensure that that is complied with, I've placed Mr. Nelson on supervised probation. In that matter, Madam Clerk, I will waive or remit any probation supervision fees. Count 2, second degree trespass, class 3, level 1. Actually, I'll consolidate that. Let me just go ahead. I'll consolidate that into the resist. Right. And that will be my judgment. Any questions, Mr. DA?
No, ma'am.
All right, thank you. Any questions, Mr. Holt?
Yes, Judge. So it's supervised probation for how long?
12 months. So I did consolidate the trespass into the resist, 30 days, suspended, 12 months, supervised probation, $500 fine, mental health evaluation, assessment, and comply with recommended treatment. And the assessment evaluation shall be with an accredited agency of the state. I will need probation to come down. So,
Yeah.
and I'm waiving or remitting probation supervision fees.
Judge, he'd like to enter a notice of appeal for trial de novo in Superior Court.
Thank you. But I still have to have probation come down and speak with Mr. Nelson, just so they have to get any identifying information beforehand. All right, Mr.
Well, his
Diaz.
probation will be
It will be
suspended.
stay, absolutely, it's stay. But at the same time, I'm going to make certain that they don't need any information. Mr. Diaz,
Yes,
you want
ma'am.
to be heard on an appeal bond?
No, Your Honor.
All right. Mr.
Well, I don't know
Cole?
if it's stayed, he shouldn't have to give them
Well, I just
information.
want to follow their protocol and make certain. That's all they're doing. It's easy.
But
There's no but. That's what I'm doing, okay? It's real easy. And they may say, we're not getting any information whatsoever, but I want to ensure that their policies and protocols are also followed with my judgment. So that being said, did you want to be heard, sir, on an appeal bond?
yes, Judge, I've never had a problem with him coming to court. He will travel as far as he has to make it to any court date that he is to be at. I have total confidence in him with respect to that. I don't think he needs an appeal bond to come to court because his track record shows that he goes to court, comes to court. I don't see what purpose it serves. He's a level 1.
The only concern is if he is living out of state. That's one factor that I'm taking into account. But on the other hand, he did appear for this hearing and stayed going into day 2.
That's right, Judge.
Let me think on that for just a second.
Okay.
Okay, why don't y'all just have a seat? Let me make sure I follow everything with gradation. While I'm waiting on probation, I do want to address the audio recording, okay? Because we have been recording this, as I indicated at the start of this trial, as an accommodation to Mr. Nelson. So I will let everyone know that I will be entering an order. You need to give me some time to prepare that order, but I need to enter an order as far as what's permissible with respect to first of all, who will have access to the recording, and once any permissible individuals receive the recording, what are the permissible uses of that recording, okay? So I can tell you now who I'm going to allow to have access, a copy free of charge of the recording on a disc will be Mr. Nelson, Mr. Cole, and Mr. Capps. I will allow any witnesses who testified, once they review my order, to listen to any of the testimony should it become necessary on the audio recording. And I will order that the audio recording, my standard language with an order like this that I've done in the past, that recording shall not be disseminated to any third person, to any other entity, to any other organization, on any blog, website, social media site. It will not be allowed, because if that were allowed, it allows individuals to take certain clips of the audio recordings and use with it as he may, and I say he because all of you are males, and it will only be the 3 of you who will be allowed to have access to it. But I did include any associates. I will include that in my standard order. I include that. And when I say standard order, do y'all know what I mean? Because y'all know that at one point I did a lot of DSS work, and in my DSS court rotations, I had to enter orders that allowed, as far as documentation, records to be received by other parties, but I would put certain conditions in if I felt that it was appropriate. And in DSS, that's confidential information. So a lot of we do it in civil court as well when it's appropriate. And in this matter, I find it to be appropriate as well. So I hope we are going to be very clear that none of the 3 of you, or Mr. Colt or Mr. Capps, any of your associates, if you have an associate, do you have an associate, Mr. Colt?
No, Judge.
Would be allowed, and that would be your colleagues, would be allowed to disseminate this information, because if it does occur, you would be subject to sanctions by the court, which could include contempt of court, whether that be civil or criminal, or any other sanction that the court would deem appropriate. Anybody, and I've got to get it prepared and get my language that would be relevant to this case versus any other type of like civil custody cases or a DSS case. So hopefully I could get that to y'all tomorrow.
Your Honor, I think I'd like to ask Mr. Nelson, my client, if he is willing, if he agrees to that.
Okay?
Agreed to not disseminate?
Yeah.
Yeah.
Okay.
I'm sorry, what was that?
He said, yeah, sure, he agrees to not disseminate.
So that includes any publication, Mr. Nelson, publication, dissemination, copying it and relaying it to a third party, or any other website, any form or fashion. It's just for you all to use, because you give a notice of appeal. It's for you to use for that, and it's for you to be able to just have access to the last 2 days' proceedings, Mr. Nelson.
Your Honor, we may use it as impeachment evidence in a Superior Court trial.
Well, you can use it, y'all can certainly use it for Superior Court purposes, absolutely.
No. He asked, is this a public record? Would someone be able to request it through a public record request? And I said no.
No, because I'm entering an order to the contrary, sir. But thank you for that question, because I'm glad we have that clarification. I want all questions out there, so there's no misunderstanding, and there's no questions whatsoever.
Right, we can't disseminate it. That's where we are.
Right.
Except for purposes of Superior Court. And Mr. Nelson gets that.
You can use it for that court purpose, right?
Right.
So in other words, Mr. Nelson, you understand, no other third person can make a request for it, because I will not allow it to be disseminated to a third person. Well, let me say this. They can always make the request, but I will enter a court order that denies that request. You understand?
I think so. I have no plans to disseminate it to anybody.
Well, and that's the thing. My purpose in entering such an order is to preserve the integrity of the legal system, and I do not in any way want anything altered, fabricated. And I'm not saying any of the 3 of you would do that. I'm just saying that's what I feel most comfortable with when I enter an order under these given circumstances. But I think it sounds like you understand, Mr. Nelson. It sounds like you do, Mr. Cole, right?
Yes, I certainly understand the order, Judge. No. I'll abide anything Your Honor asks me to do.
I know you will. I want you to make certain that you explain everything clearly to Mr. Nelson, but it doesn't sound like, Mr. Nelson, you have any questions about that, is that correct?
It was just it was public record, and I think we clarified that. So if it's public record, the public can have it. If not, then they can't.
Correct. Correct. If a court order is entered that says you cannot have it, then you cannot have, then it's not considered public record for those purposes. Do you understand? Whether it's, and I say this on several occasions, whether you like the ruling or not, that is what my order will say. All right, so Madam Probation Officer, thank you for appearing. I wanted to, Mr. DA, you understand everything that I said?
Understood.
Okay. So Madam Probation Officer, thank you for coming over, first of all. I'm most appreciative. I would like to ask you, I just entered a ruling in a case, and Mr. Holt has just entered notice of appeal on behalf of his client. And I placed his client on supervised probation. You know, as you know, that stays the conviction until it is heard in Superior Court. But I wanted to ensure that I'm following proper probation protocol. Does probation need any information from Mr. Nelson whatsoever?
Not today, Your Honor. It's only the ones that's in Superior Court, we would take them downstairs and process them like a normal case. But anything district-wise, and I would consider this kind of like district, we would just let it go, and it'll just go in appeal. And I have a way of keeping track of it, so when the court date is, and if judgment is actually entered on it, then the case will dissolve in the appeal case then.
Okay.
But as of right now, if he's appealed in open court,
So you
we
have
do
track,
nothing.
you have his name and you have track of it?
Yes, Your Honor.
Okay. All right, then, if you have that, then excellent. All right, that takes care of that. Thank you so much, ma'am.
Thank you.
All right, I would say, with respect to an appeal bond, I do think Mr. Nelson will be here, but I have to say, if he is in fact living out of state, that's my only concern. Because then, if Mr. Nelson leaves, he doesn't have to come back, and it would be a matter of, would we go through the process of an extradition? Or something like that. Mr. Nelson, what state are you living in?
Stand up.
Prefer not to disclose that.
Don't put your hands in your pocket, sir.
I'm sorry?
Take your hands out of your pocket.
Hands
Thank
up.
you.
Hands out of your pocket. I'm sorry, go ahead, sir.
Yeah, I prefer not to disclose where my residence is for my family's safety.
Okay.
But I've been to court numerous times. I've made the 15-hour travel numerous times in Rockingham County, in Wake County. And we have something pending in Rockingham County in 2 weeks, so I plan on coming back in 2 weeks.
And Judge, the safety issue is very real. On his case in Rockingham County, I made a motion to change venue. He did some activism in Madison, North Carolina, and there were caravans of people who, there was a protest in downtown Madison, North Carolina, directed at him. He's received, yes, multiple death threats, horrible death threats to his family. His house has been vandalized, people threatening to kill him. I told him he had to get out of Madison, or he was going to get killed. The stuff that I saw and that he's told me. And there's a record of all this in my motion to change venue, which was denied, but it was a very serious situation, and he's doing this not to be difficult. He just has very real concerns.
Okay. All right, so you mentioned Rockingham and you mentioned Wake. Are there pending criminal matters in Wake?
He had he had a case in Wake that was dismissed.
That was what, I'm sorry?
Dismissed.
He was adjudicated and found not guilty.
Okay.
Oh, it was?
Yeah.
Sorry.
You
Yeah.
found not guilty? Okay. And when was that heard, sir?
Goodness, that's, I want to say the 23rd of July?
Of this year?
Yes, ma'am.
Oh, okay.
Yeah.
So
And
you went,
I've been there twice. That was, there was a pretrial, I had to go travel by train, and then, came back again, I think a month after that for the trial.
He's been doing better legally without a lawyer than with one, I'll tell you that.
So,
Mr.
yeah.
Holt, you did an excellent job advocating for Mr. Nelson.
Thank you, Judge.
And Mr. DA, you did an excellent job advocating on behalf of the state.
Thank you, Your Honor.
So, I say that. All right. And you have not missed any appearances in court in Rockingham County?
No, ma'am.
They accused him of it, but he was there at the courthouse with me, and he got hung up in security, and there was a problem with his request to use for assistive devices as in Guilford County. And he couldn't make it up to the courtroom in time. I went up to the courtroom and said, Judge, he's down in security. I just saw him. He can't get in. And he wanted to bring in assistive devices. They were saying you can't come in with those, and it got really confusing, and the judge got frustrated. And he was, there was a failure to appear.
Okay.
But he was
But
there.
he's at the courthouse?
He was there.
Outside or right out there? Okay.
Yes.
All right, I won't set an appeals bond then. All right, so we'll leave it as his, what were his pretrial release conditions? That's what goes into effect then. I won't change or modify that. It was a written promise?
Yes, ma'am.
All right, so it'll remain, it goes back to his initial pretrial release conditions, and I won't modify that.
Thank you for that, Your Honor.
All right, thank you.
Thank you.
That's the business for the state, Your Honor.
All right, thank you. And I will send the order, Mr. Holt and Mr. Capps, to you both. And certainly, Mr. Holt, you can disseminate that order that I entered to Mr. Nelson.
Okay.
Can we get that in a OCR readable format? The permit that has been being passed and forth by Stephanie Wallace is not, I have not been able to read it or verify what it says at all.
An OCR format?
Yes, ma'am, it's optical character recognition. It's so that a screen reader can read whatever the document is.
I will certainly provide that to you, Mr. Nelson, if I have access to that. I only have access to what the state gives me access to.
It
Does that
should be
make
a
sense?
simple click on Adobe. If the clerk has Adobe or if you have Adobe, ma'am, there should be an option for OCR.
Okay. Do you have Adobe, Madam Clerk? We're gonna get that figured out, Mr.
All right,
Nelson.
thank you.
Okay, you're welcome.
Is Boyce still here?
De Opresso Libero.